Now get across and focus on what's happening as far as home buyers are concerned. Nilang Desai, partner at AZB, is now with us. Nilang, thanks so much for taking out time for us. Could you just talk about SC upholding IBC changes? What does this mean?
Sure, yes. I guess what's happened is, as you know, the IBC was amended last year to reflect home buyers who had given advances for their homes but not got their homes as financial creditors under the IBC. And that gave them a say on the committee of creditors. It gave them a participation, basically, in the process, which they did not have earlier. And the builders came out and attempted to challenge this on the basis that they aren't your traditional financial creditors and should not be given that treatment. And I think we've got a constitutional confirmation now by the Supreme Court that actually, no, it's fine for home buyers to be financial creditors and have those rights, and that it does not infringe the builders' rights.
Okay, but you know, in light with how you read into the provisions made in the RERA, how are these two? How should these two be read together?
I think the judgment, I haven't got the copy of the order just yet, but I think what the judgment is saying is that the IBC overrides RERA on the one hand, and on the other hand, the homeowners are able to take protection either under the Consumer Act or RERA or IBC as they deem fit. This is helpful because while the ability of the homeowner is unrestricted, once one is an IBC, I think there would have been confusion otherwise as to whether rights under RERA prevail or the opportunity under IBC prevails, and I think that's been clarified.
Right, and how big a relief would this be overall?
I think it depends on whose perspective you're looking at. From the perspective of a homeowner, certainly I think a relief, because there was a situation earlier where not only did you not get a seat on the committee of creditors, but arguably you couldn't even start an IBC process against a builder. So I think that's been clarified, and therefore from a homeowner's perspective, that's very useful. From a builder's perspective, not the greatest, because you now have disparate homeowners who can attack you from an IBC perspective. Having said that, that's what any other borrower in the market is subject to. So maybe the way of looking at it is that a builder is no different from a borrower vis-a-vis its homeowner, and therefore it should be under the same pressure.
You know, home buyers who may now be able to initiate insolvency proceedings, that's fairly big. Could this have any kind of discord between lenders and homeowners as well, now that both have a fair amount of say in the process?
No, so as I said, I think this right was there as soon as the law was changed to include them as financial creditors. This judgment only confirms that that right available to them as a financial creditor is fine for them to have. Does it create discord? I don't think so. At the end of the day, no home buyer wants to pull down a developer for the sake of it. He only wants to make sure that he gets his home, and it's only a situation where he's not getting his home. I would expect that he would put undue pressure on he would put pressure on the builder. To the extent there are vested and motivated home buyers who are trying to pull down, say, a competitor or any other reason, I think it's possible for a court to see through it, and frankly it's possible for potentially the builder to pay them off or settle with them if he's otherwise healthy.
Right, Mr. Desai, thanks so much for taking out time for us. Always good to get perspective from you.